morning to one and all present here. My name is Raymond.
And myself Rituja.
And
we welcome you all for today's symposium on artificial intelligence, privacy, security and intellectual property rights.
It is my distinct honor to host today's event on intricate legal challenges presented by technological innovations in artificial intelligence. To inaugurate our symposium, we begin with the traditional lighting of the lamp. The lamp is a timeless symbol of knowledge and new beginnings. The dignitaries are requested to kindly light the lamp. The honorable dignitaries are now kindly requested to grace the dais.
A computer would deserve to be called intelligent, as Alan was believing that it was human. In today's world, machines do far more than just imitate human intelligence. They assist in decision making, create content, analyze vast data sets, and interact in ways once thought was unique. Artificial intelligence is no longer the future, it's the present. But with the rapid rise comes some critical questions. What happens to the privacy in the world of surveillance and algorithms? Who holds the intellectual ownership when machines create? And how do we safeguard security in the age of autonomous systems? We are gathered here today to explore these complex intersections. This symposium is our collective effort to delve into legal, ethical, and technological challenges that AI presents, especially in the domains of privacy, security, and intellectual property rights. In the first half of today's program, we'll hear from our distinguished experts who bring invaluable insights into these pressing issues, and the second half will feature paper presentations offering academic and research-driven perspectives from scholars across borders.
I would also like to extend a very warm welcome to the dignitaries present here with us. Respected Vice Chancellor, Professor Dr. Dilip Ukey sir, our Registrar Dr. Pratap Singh Saluke sir, our Chief Guest, Honorable Mr. Justice Ujjal Bhuyan sir, Judge Supreme Court of India, our Guest of Honor, Dr. Birendra Saraf sir, Advocate General State of Maharashtra, our distinguished speakers, Ms. Ankita Hariramani ma'am, Partner Spice Group Legal, Ms. Gauri Gokhale ma'am, Independent Legal Counsel and Advisor, Ms. Pooja Kapadia ma'am, Principal Associate at Cyril Amarchand Mangaldas, along with the Chief Guest for Valedictory, Mr. Sachin Daga sir, Managing Partner, Daga Legal, and our Guest of Honor for Valedictory, Dr. Ivreet Kaur Walia ma'am, Registrar in Charge, RJNUL Patiala, all our respected faculty members, and our dear participants. I would now request Professor Dr. Dilip Ukey sir to kindly felicitate the Chief Guest, Honorable Mr. Justice Ujjal Bhuyan sir.
We are also honored to have our special invitee, Mrs. Sanghamitra Das Bhuyama. We request Professor Dr. Dilip Ukey sir to felicitate her.
I further request Professor Dr. Dilip Ukey sir to felicitate the guest of honor, Advocate Dr. Birendra Saraf sir. I would now request Honorable Registrar Sir to felicitate our dignitaries for today. Mr. Sachin Daga Sir.
Ms. Ankita Hiranamani ma'am, Spice Room Pvt.
I now request Ms. Gauri Gupte ma'am. Dr. Irneet Kaur Walia ma'am. Before we proceed, I would like to extend our heartfelt gratitude to our partners for this event. A special thank to Daga Legal, whose support and collaboration have been instrumental in making this symposium possible. I would also like to thank our publishing partner, All India Reporter, knowledge partner Manu Patra, and media partner LiveLaw.
Maharashtra National Law University Mumbai, established in year 2014, is one of the premier national law universities in India. Honorable Justice B.R. Gavai is the Chancellor of the university, who not only guide but also inspire the institute with his novel ideas and rich experience in the field of law. Our Vice Chancellor, Professor Dr. Dilip Ukey sir, a renowned academician in law with varied experience of teaching and research. Our pillar, our Registrar, Dr. Pratap Singh Salunke sir, supports us through his vast network, resources, and administrative legal practice experiences.
This event is hosted with the joint collaboration of two centers, CICTL and CALSTAR. CICTL, or the Center of Information, Communication Technology and Law, serves as a link between technology and law, providing essential information and acting as a hub for both legal and tech professionals. CICTL examines the advantages and the challenges of the information society while offering a range of legal and regulatory solutions. Our goal is to collaborate with international academic institutions, organizations, and research centers to deliver high-quality techno-legal services.
CALSTAR, the Center for Advanced Legal Services, Training and Research at MNLU Mumbai, was founded with the goal of creating a holistic and integrated platform for our academic, research, and training initiatives in ever-evolving field of law. The center aims to become a prominent hub for legal education and research, contributing to the development of modern and forward-thinking legal frameworks that tackle emerging challenges. It seeks to bridge the divide between theoretical legal education and practical application, ensuring that the legal professionals are fully prepared to address the demand of fast-changing world.
I would now request the Honorable Registrar Sir to deliver the welcome address.
Respected Honorable Justice Ujjal Bhuyan Sir, Judge Supreme Court of India, Mrs. Sangamitra Bhuyan Ma'am, Advocate Dr. Birendra Saraf Sir, Advocate General Government of Maharashtra, our Vice Chancellor Professor Dr. Dilip Ukey Sir, all other dignitaries and the guest speakers for the technical sessions, all the partners who associated in this symposium, faculty members, students, and those who contributed for organization of this symposium. Few days back, there is a very interesting book which is published by Anthony Lowenstein, The Palestine Laboratory. How the spying and other softwares, we always heard about Pegasus, identical such kind of a spying softwares were used by Israel in the Palestine, and they advertised it on the large scale that these are the tested on the field. So that field is the battlefield. And it is not on the guinea pig, but it is on the real human beings. The interesting part is the person who is the author of this book, he himself is a Jew. So initially he was also applauding the kind of efforts which were taken by the Israeli government about spying and all such kind of surveillance. But later on he realized a deep-rooted kind of challenges behind the scene. So it invited the concerns regarding the security. It also raised the concerns regarding the privacy. And all over the world, because few years back, especially in 2013, Anil Kapoor faced this attack on his personality because there were many memes, many images which were used for the commercial purpose, stating that this is the advertisement and the endorsement by Anil Kapoor, and that's why the top brass lawyers, they argued the matter before the Delhi High Court, stating that Anil Kapoor as a leading actor is having a right to maintain the dignity and integrity of his own personality. And that's why Anil Kapoor versus Simple Life and Others 2013 judgment, which talked about this particular aspect which is related to AI, because all the images which were used for the endorsement purpose, those were not the realistic one where actor had signed any kind of agreement having a commercial kind of element into it and which gave a consent for the scene. So such kind of issues, even the Asia News International also raised an alarm for use of certain logos and content internationally, and which claimed a lot of such kind of issues which are associated to it. So if you just glean through the symposiums, conferences, seminars these days which are organized, AI has become the buzzword. But is it something which is only of a recent origin and it has no connection with the past? It is not so. If you refer an essay which was written by John Stuart Mill way back on liberty, in which he referred one very interesting point and which is very aptly applicable over here. He pointed out that man wanted to have a liberty, and man always loves liberty. but liberty of own, he himself or herself. He or she may not respect equally the liberty, privacy of others as well. And he cites the examples, man wanted to reach from one place to other in a very shortest possible timeline. So what he did, he invented buggy. So he employed horses, bullocks for that particular work. So the use of animals, it was to have more liberty to the humans. That is also an indicator of the same concept. The bottom line of AI is also about taking a shortcut for all the human labors, because all of us always love to cut short and to take a shortcut, but we neglect one very important aspect, that whenever we avoid the long cut and take a shortcut, shortcut itself is having its own inherent dangers. When you are avoiding a long cut and taking a shortcut from a forest, it is having all reptiles and all other such kind of dreaded animals into it that we cannot neglect. We cannot pick and choose. So these ethical, moral aspects which are also associated with these subject matters. Justice Puttuswamy judgment has also cautioned about the privacy, in which the same issue in relation with the individual right to maintain his or her own privacy that needs to be taken into account. And these days, the kind of applications to which we download, the consent which we give, and because of which its intrusion into our private life, now that has become the reality. So it also reminds me the initial discussion and deliberation of globalization, privatization, liberalization, and initially people resisted and then realized that we have to live with it. So that is also applicable to AI, privacy, security, and the intellectual property, and the cross sections and crossroads. We have to accept that this is the reality. So people will always love, instead of investing entire life to learn the strokes like M.F. Hussain or any such kind of a painter like Picasso, it is always easy to just ask the machine to learn those strokes and to have just that particular picture in few seconds. And now the new challenges are, there are new images, there are new creatures, there are new kind of personalities which are created by these AI. Now the entertainment industry is also facing a challenge that coming years and even coming months, entire movie that can also be created by using AI generated characters. So no more actors, no more actresses, no more technicians will be required, and they will also have the equal kind of a brandishing their own acting skills and all such kind of aspects. So ethical, moral, and all such aspects which we have to also take into account. So deep rooted our own ethical and moral aspect from jurisprudential sense, that also we need to deliberate, and not only the technocratic sense we need to discuss in all these deliberations, because it is always said that law is expected to act like a last line of defense. It is not first line of defense, it is the last line of defense. And that's why all these mechanisms, that also we need to take into account. And I resort to one couplet which will help us to understand this phenomenon. उम्र भर ये खता हम करते रहे, धूल चेहरे पे थी और आईना साफ करते रहे. So this aspect, which I think is very important. So once again, I welcome on behalf of our Honorable Vice Chancellor Professor Dr. Dilip Ukey sir, entire management of Maharashtra National Law University, to our respected Chief Guest, Honorable Justice Bhuyan sir, Advocate Dr. Birendra Saraf sir, Ankita Hiraramani ma'am, Pooja Kapadia ma'am, Gauri Gokhale ma'am, Ivnit Kaur Walia ma'am, and Sachin Daga sir, and all the persons who are presenting their papers and their research work in this symposium and the entire galaxy of the volunteers, because for last few months the kind of pains which they have taken to make this particular event a grand success under the leadership of Asta Tiwari ma'am or Miss Shweta ma'am and their entire team of CALSTAR or CICTL to make this event a successful event, because it is always said an individual can blow a whistle, but it requires an orchestra to play a symphony. And that's why this particular teamwork, it has paid, and this particular grandeur, what we see, is also because of their kind of pains and efforts which they have taken. So once again, I welcome all the dignitaries and all the persons who have helped us to organize this particular event. Thank you very much.
Thank you so much, sir. Professor Dr. Dilip Ukey, sir, has been a monumental figure in legal education and policy, having served as Pro-Vice Chancellor and Acting Vice Chancellor at the SRTM University in Nanded. His tenure at Pune University as Professor and Head of the Department of Law saw significant advancements in legal education framework. Professor Ukey has represented our nation in various international law conferences, bringing his insights into human rights and legal education to global platforms. I would now request Honorable Professor Dilip Ukey, sir, to deliver the presidential address.
Chief guest of today's program, Honorable Chief Justice Ujjal Bhuyan sir, Mrs. Bhuyan madam, the guest of honor, Advocate Dr. Birendra Saraf sir, the Advocate General of Maharashtra, all the guest speakers and the guest of honors of Valedictory program, the partners, Advocate Daga and others, Ms. Dilip Ukey, Dr. Keynote, our registrar, Dr. Ukey, my colleagues, all the participants and dear student friends, a very good morning to all of you. The Maharashtra National University, which was established in 2014, we started our academic journey from 2015 onwards. And since then, we try to take every step to enhance the quality of legal education, establishing various different centers as well. As Dr. Ukey had pointed out, why this conference, why this symposium? Because in today's world, in today's time, artificial intelligence has become so important one, and it has spread across the world. Keeping the need of the hour, and that's the reason over two centers they have joined hands together and decided to organize this symposium on AI, security, privacy and IPR issues. As we know that with the advent of science and technology, wherein human endeavors are virtually carried out by artificial intelligence, to what extent these shifting paradigms will affect IP rights, privacy and security in present days, that needs to be deliberated, debated and discussed as such. In late 19th century, various scientific fictional movies came up with the concepts of robots, which will make a human life simpler in all senses they want. The fictional creativity depicted that robots were replica of human beings, not made of flesh and bones, but of wires and bolts. They could feel, sense, see, analyze, emotionalize, and made decisions for themselves in a similar manner as a human does. The concept which was there in human mind literally became virtual reality. With the development of science and technology, we have virtual devices and gadgets which have made our life easy, where the labor by human is replaced by command by AI. As you know, Deep Blue, an AI machine, was successful in beating the world chess champion Garry Kasparov. Though Deep Blue lost further matches, but so many fans were reflecting the confidence in Deep Blue than Kasparov. A humanoid robot created by Dr. David Hansen, named Sophia, is the citizen of Saudi Arabia and first robot to have a legal personhood. She is a great example of AI vis-a-vis virtual reality. AI could become as the ability of the machine to analyze like a human brain. It is a science which finds its genesis on the basis of the human nervous system and the natural abilities inculcated into the same. In recent times, the development of technology in relation to AI is creating a thunderbolt in the field of science and technology. How legal system, legal regime responds to that is a big challenge as well as a question. The term AI was coined by Alan Turing, who, through his genius mind and hard efforts, managed to decode the Nazi Germany's ciphers produced during the World War II. He also wrote a seminal paper on the concept of machine intelligence in the year 1950. Just imagine how many years before. He postulated the famous Turing test. According to it, if a human could converse with a computer and is fooled by the clever techniques used by the machine, believing it to be another human, then the machine has passed the benchmark to clear the test of intelligence. Artificial intelligence can be considered as an activity which makes a machine intelligence. Though the versatility of human intelligence with the abilities to reason, achieve goals, understand and generate language, create art and music, and even write histories is unmatchable, but an effort is being made to allow machines to perform a minimal part of the oceanic capabilities of the human brain. AI could be defined as the development of computer systems which enables them to perform the activity of human intelligence. The world of artificial intelligence has progressively changed from a fictional reality to virtual reality. The voice recognition software, the language translators, the smart learning machines, the automatic temperature control sensors, employing of robots in industries and various other institutions, automatic tagging sensors in automobiles give a wide perspective of the incorporation of artificial intelligence in our day-to-day lives. Many consider artificial intelligence as a term which inspires the system to work based on biological information provided to it. Marvin Minsky, an American research scientist, is duly credited as the father of artificial intelligence by developing SNAR, Stochastic Neural Analog Reinforcement Calculator, the first randomly wired neural network learning machine in January 1952. He authored a book, Perceptions, in 1969 that was a profound work in the field of AI. Compelling evidence of such revolution, people pointed out to the Predator drone, a pilotless robot plane that is now targeting terrorists with deadly accuracy in Afghanistan and Pakistan, cars that can drive themselves, and Asimo, the world's most advanced robot that can walk, run, climb, dance, and even serve the public. But upon closer examination, there is less than meets the eye. Certainly, tremendous breakthroughs have been made in the last decade or so, but things have to be put into proper perspective. The Predator, a 27-foot drone that fires deadly missiles at terrorists from sky, is controlled by a human with a joystick. A human, most likely a young veteran video game, sits comfortably behind a computer system, a computer screen, and selects the targets. The human, not the predator, is calling the shots, and the cars that drive themselves are not making independent decisions as they scan the horizon and turn the steering wheel. They are following a GPS map stored in their memory. In 1965, AI pioneer Herbert Simon declared that machines will be capable within 10-20 years or later of doing any work a man can do. But then the reality is settling. Chess-playing machines would not win against a human expert and could play only chess, nothing more. One fundamental problem, as mathematicians now realize, is that they made a crucial error 60 years or so ago in thinking that the brain was analogous to a large digital computer. But now it is painfully obvious that it isn't. The brain has no Pentium chip, no Windows operating system, no application software, no CPU, no programming, and no subroutines that typify a modern digital computer. In fact, the architecture of digital computer is quite different from that of the brain, which is a learning machine of some sort, a collection of neurons, and constantly rewires itself every time it learns a task. There are two problems of AI robots. The first problem is pattern recognition. Robots can see much better than human beings, but they don't understand what they are seeing. The second, robots do not have a common sense, which human beings do have, hopefully. AI has been trained to benefit the human society at large and to produce and provide such outcomes which are similar to the ones made by a human being, or even better, where there are chances of less error or even no error. While a huge chunk of society may highly benefit from the sum of applications of AI, it might hurt the rights of other cohabitants of the society. Right to equality, freedom of speech and opinion, right to information, right to social security, etc. are some of these rights which can be impacted by the existence of artificial intelligence. The single most affected right would be right to privacy by the AI system, and that's what rather it is a topic for the discussion today. With the coexistence of AI, it is necessary to understand that along with the positive impacts, there are some adverse effects which are being gifted by AI to the society. With AI coming into our lives and with development and entering into each and every realm of our lives, it would not be wrong to mention that the next or new generation will be having a better life in comparison with the present one, the existing one. We can say so, as AI along with the automation of the industries are providing higher productivity, increase in the efficiency, better or higher safety standards, greater economic growth, and more convenience. AI will help in promoting and providing right to equality and work. With the use of AI software system, the existing biasness in relation with the society and the social norms existing in the society can be sidelined, and equal opportunity can be granted to all on the basis of their skill and education. It might also help the government or the administration to make better policies and decisions, hence providing fair and equal treatment to all. Along with it, it can help in providing equal pay for equal work and would even help to curb unjust promotions in competitions. Various digital job finding platforms or social communities like LinkedIn, etc., are using algorithms to increase overall productivity by matching the right people for the right job. They increase their search capabilities, which help the human resource personnel to find the efficient person as per their company's requirements. It is time efficient as it helps in cutting down the time spent by the employees and the employer in finding each other, and hence makes the hiring process much efficient and simple. A study was conducted by McKinsey's Paris office in 2011, which showed that with internet coming into use, 5 lakh jobs have been eradicated from France during before that 15 years before. But it has provided 7 lakh jobs more than before. So it shows that otherwise kind of adverse impact which we are talking about, losing the job, that may not be true as such. As we know that artificial intelligence is the product of innovation and novelty. The creator needs to protect his creative work and rights accrued to him. This interface between AI and IPR is a matter of discussion and debate today. Copyright is the first of its kind of intellectual property rights which was granted recognition in the law initially. Patent is another type of intellectual property right whose correlation could be found with artificial intelligence. Patent is the monopoly right granted to the inventor of the innovation. The Indian Patent Act provides the mechanism for the recognition and protection of that right. European Union has enacted the UE Artificial Intelligence Act in 2024. The primary object of the act is to boost the uptake of AI, which is human-centric and trustworthy. Simultaneously, it also ensures a high level of protection in the field of health, education, environment, and also to protect fundamental rights mentioned in European conventions and charter. There are certain few points like the deepfake, as well as the AI which have been developed, AI which has developed robots which have been deployed at the border for the security purposes. Our Digital Personal Data Protection Act, which is based on GDPR, also deals with about the issue of privacy. Maybe in a coming age, there will be the increased use of the AI as well as the internet as kind of gadgets and internet of things which is there, which is being witnessed and experienced today. It seems that at some point of time, we may require a kind of a digital detoxification. In view of this, it is necessary to deliberate. I do not wish to commit a trespass over the topics which have been assigned to the guest speaker, be it human rights, be it IPR, be it issue of privacy, etc. I once again welcome all the dignitaries and thank all the guests who are here to deliberate and enlighten all of us. Thank you so much.
Thank you so much, sir, for your insightful address. We are honored to welcome Advocate Dr. Birendra Saraf, Senior Advocate at Bombay High Court and the current Advocate General of Maharashtra. With over 25 years of distinguished legal practice, Dr. Saraf, sir, is renowned for his expertise in constitutional, commercial, civil, arbitration, and intellectual property laws and has appeared in several landmark cases. A graduate of Government Law College, Mumbai, where he has consistently ranked top, he went to complete his PhD on judicial intervention in arbitration in India. Early in his career, he trained under Justice D.Y. Chandrachud and former Advocate General Ravi Kadam. Dr. Saraf sir has been an active contributor to the legal community and has served as Honorary Secretary of Bombay Bar Association for 6 years and is currently serving as a Vice President. His appointment as Advocate General that stands as a testament to his legal acumen, scholarship, and leadership. I would like to request Dr. Birendra Saraf sir to deliver his address.
Honorable Justice Ujjal Bhuyan, sir, Madam Bhuyan, Dr. Ukey, Dr. Salukey, the guest speakers for the day, the faculty members of MNLU, and my dear friends. You all have heard pretty heavy stuff since the morning, so let me start with an internet joke. I found it very interesting and apt for the topic for the day. So there is this person who wants to order a pizza, and he makes a call, and the other side there is a machine now, because the pizza delivery service is taken over by a IT company. So there is a machine using an AI tool which answers, and he says, I want to order a pizza. So the machine says, will it be your usual one? He says, what's my usual one, and how do you know that? The machine says, well, out of last 10 times, you have ordered 8 times a double cheese pizza, which is also stuffed with cheese. So, would you like to have that? He says, yes, that's what I would like to have. The machine says, rather, I would recommend that you have one with some broccoli, some mushrooms, and some onions. Says, I hate vegetables. So, machine says, but sir, your cholesterol is very high. So he says, and how do you know that? He says, from our database, we have seen that your last 3 blood reports show that your cholesterol is very high. The man gets quite anxious and says, but you don't have to worry about that, I'll be taking medicines for that. The machine says, sir, but you are not regular with your medicines. Your last purchase of medicine on the pharma app was 3 months ago, when you purchased only 30 tablets. Machine then doesn't stop. The person says, I bought from a pharmacy. He says, sir, your credit card statements don't disclose that. He says, I bought it cash. He says, but your bank account statements do not show any withdrawal in cash. He says, but I had some other cash. He says, sir, your returns which you filed with the authority does not disclose that you have disclosed any other source of income. Do you have any other source of income? So man gets really frustrated, and finally says, I don't want to order any pizza, I don't even want to live here, I want to go on some island where there is no internet. The other side machine says, sir, but your passport expired 6 months back. So this is really what we may end up being in no time. It may be very soon, then you know. And the question which arises from this, though funny, is something very serious, that today we are in an age where just about everything about us is somewhere on the domain of internet. And that data we are providing to various companies, various agencies, and innocently we might be providing that data to somebody, some entity, and they are all collated and then be used by different entities for different purposes. And that raises a lot of other questions. So we may start our day by asking Alexa, or maybe that's only a name of any other software or AI tool, to put on your coffee machine. And you may end up your day by asking it to shut off your lights. But each of your day's pattern is being recorded somewhere. So the day you do not put off your light, it's possible that that AI tool will remind you it's time to sleep. If you have not taken your medicine, it will tell you that you have not taken your medicine. So entire life of yours, every step that you take is a pattern. And that pattern is being recorded somewhere and utilized by that, not just that agency, but various other agencies. Your data may be sold to someone, your data may be given to some other agency. And that is where the core of this discussion of today's subject lies. And therefore, what is artificial intelligence? It's an integral part of our life today, and it's only going to increase. It is there to stay. There is nothing that we can avoid this now. And it, of course, makes our life smooth in many ways. It helps improve our day-to-day life by enhancing efficiency and productivity. it improves resource utilization, it makes faster decision making, improve accuracy, development of new product and services and what not. It just does everything for you. Complex tasks are handled with ease and reasonable accuracy in far lesser time. Now, it is all about, largely about pattern recognition, detecting trends, self-learning from data sets and making predictions. The more data you feed, and this I am talking of the very basic AI, the more data you feed, the more accurate the analysis and the consequent prediction. And the rapidly growing amount of data generated makes it impossible for humans to interpret the same, which drives the need for machines to identify patterns quickly and accurately. But the growing use of AI is raising various issues with the present set of laws and regulations are not ready to meet. In the context of AI and intellectual property, multiple issues are raised all over the world, and the present state of law is surely not ready to deal with it and to meet such situations. For example, if there is a work such as a music or a photograph which is created on an AI, the question which usually arises is, who is the owner of the work which is created using the AI? Is it the developer of the AI tool? Is it the user who created the work by giving inputs into the AI tool? Or is it the AI tool itself? So these are questions which jurisdiction all over the world are groping with. And the traditional concept of copyright contemplated original work which was created by a person as in a human by the use of sweat of the brow. But will this apply to something created by an AI? It could be said that after all, it is a human who created an AI. But will that copyright be in that AI tool or the product which has come out by using the AI tool? There is a very interesting case of an Indian, Mr. Ankit Sahani, who generated a photograph using an artificial intelligence tool called Raghav Artificial Intelligence Painting App. So he took a picture of a sunset and thereafter put that picture on an AI tool and asked the AI tool to create a photograph using a copy of Van Gogh's painting Starry Night. And a new image was created. The sunset photograph which Mr. Sahni took and the painting of Van Gogh were merged together. And a new painting or a new picture came out which he named Suryast. And he applied for registration of the copyright in that AI tool. He initially filed an application in India saying it is the AI tool which is the owner of the copyright in that photograph Suryast. The registry did not grant it. Thereafter he applied again, calling himself the author of the photograph and of the work and Raghav AI as the co-author. Now this time the Indian registry registered the copyright, recording him as the author and the AI tool as the co-author. But in November 21, the registry thereafter issued a notice of withdrawal. He also tried to file a similar application in the United States. That application was rejected. A second request was made by Mr. Sahni in December 23, and the United States Copyright Board refused to register the copyright in that photograph. The United States Review Board held that AI system cannot be the author of a copyright. Now, in December 2021, Mr. Sahni filed a similar application for registration of the copyright in Canada with two authors, that is Mr. Sahni and the Raghav AI tool. And it appears that in Canada, the grant of copyright registration is quite a procedural thing which is driven by the computer system. And therefore, a registration was granted, and thereafter a rectification application is made challenging the registration to say that Raghav is not a legal entity, it is not a natural person, and therefore there cannot be a copyright which can be owned by that artificial intelligence tool, and also that there is no originality in that work. So therefore countries all over the world are groping with this issue of copyright in a work generated using an AI tool. And the law as it stands today seems to be largely that it has to be a natural person to own a copyright, and these are issues which jurisdictions all over the world are groping with. There is a similar case of Mr. Stephen Thaler, who also tried registration in a AI system known as Creative Machine, and that also has gone through a similar journey in different countries and different jurisdictions and facing a lot of difficulty in the registration. He also applied for a patent for an invention conceived by an AI system. So Mr. Stephen Thaler applied for copyright and then also applied for a patent in respect of another AI tool. In 2021, South Africa granted his application, and it appears that South Africa also has quite a procedural system of registration. However, various other jurisdictions, including United States, New Zealand, United Kingdom, and various other jurisdictions, rejected his application and said that an inventor has to be a natural person. Now, that issue finally ended up in a United States Court of Appeals, and these issues were noted by them. And after this decision, the United States Patent and Trademark Office published an inventorship guidance for AI-assisted inventions, which inter alia stated that AI-assisted inventions are not categorically unpatentable for improper inventorship. The patent application and the patent for AI-assisted invention must name the natural person who significantly contributed to the invention as the inventor or joint inventor, and such application and patent must not list any entity that is not a natural person as an inventor or joint inventor. So it said there could be an invention taking the assistance of an AI tool, but that patent in that product cannot be owned by the AI tool itself, but it should be owned by the natural person. Now, this at the same time raises an issue of copyright in the data which is being used by the AI tool. And does the use of copyrighted data and material for training an AI system, does it tantamount to an infringement of the copyright in the data which is being used to train the AI, or is it an infringement, or is it a fair use within the meaning of the Copyright Act? These are issues which are now being dealt with by the Delhi High Court in a case, and also similar issues are pending in the US in certain cases. Now, as AI grows more sophisticated and widespread, the voices warning against potential dangers also grow louder. Geoffrey Hinton, known as the godfather of AI, left his position at Google in 2023 so that he could talk about the dangers of AI. He went on to say that a part of him even regrets his life's work. And there are various concerns raised about AI. The primary being transparency. Many companies which are promoting an AI tool or AI facility remain tight-lipped about their products, and this secrecy leaves the general public unaware of the possible threats. There is also a complete absence of human influence, and this has led to an absence of factors such as human empathy and compassion. And there are larger social issues which are very serious and pose a genuine threat. Social manipulation is a danger of AI. AI voiceovers as well as deepfakes are infiltrating the social and political sphere. These technologies make it easy to create photos, videos, and even replace the image of one person with another in an existing photo or video to the extent that it is difficult to distinguish between the credible and the one which is AI generated. For example, in 2022, a deepfake video of the Ukrainian president was broadcast instructing Ukrainian soldiers to lay down their arms and surrender. This deepfake picked up so fast that it could have done immense damage. And there is another example in 2023 of a deepfake of Mr. Ratan Tata giving certain advice on financial aspects. We had a case where there was a deepfake of the managing director of the National Stock Exchange, where it was shown that he was giving some advice or tips on stocks. We had to file a case in the Bombay High Court. I appeared in the matter for NSC, and we had to have all those deepfake videos removed by getting an order from the court. And the court also gave certain other directions as to how such deepfake videos should be removed, which are being contested by some of the platforms such as Google and Meta and all that, which is being considered now. Now there are also issues of data privacy involved. Now, when such data is collected and used without the express and valid consent of users, it raises ethical concerns. There is the risk of this data being cloned and thereafter misused by cyber criminals. Cyber attacks being committed on AI systems themselves may give rise to private and sensitive information being leaked, and vast amounts of it at that. So there are two kinds of the invasion in privacy. One is the AI tool itself collecting your other data from other sources and using it to train itself. And then the second issue is the data collected by the AI tool itself from you, which is being used for some other purpose. So these raise serious concerns of privacy and other issues which need to be dealt with. Now there are also other issues of AI and security. We all know how AI is being used for various criminal activities. We regularly hear about voices of relatives being created to get people to part with money, issues regarding virtual arrests. They are now live and current and being faced. We have read in the newspaper that certain senior citizens were kept under virtual arrest for 2 to 3 days and thereafter made to part with a huge amount of money. So these are serious concerns which need to be dealt with. As Dr. Ukey also said, that there are issues of mass surveillance and facial recognition which are raising issues. And this could lead to various erroneous findings. In the United States, a man was wrongly arrested due to reliance of authorities on facial recognition technology, and he spent 10 days behind bars for a crime he didn't commit. He stated he was released only after he provided evidence that he was in another city making a money transfer at the time of the offense. And that is only because the facial recognition AI tool which was used committed a mistake. So these are various issues which we can go on and on with, which you all are aware, and they are much more serious than what we really conceive or we can think of. The recent thing today, the happening thing in the social platform is that Chat GPT, everybody is going about with the Ghibli portraits which have been created. I have to Google to see whether it's Ghibli or Ghibli, I think it is Ghibli portraits. So that is the current thing, everybody is doing it. Yesterday my son created a photograph of us and sent it to me. Very exciting, but it raises great deal of intellectual property issues, whether the copyright which rests in Ghibli studio of Japan is being violated or not. Intellectual property experts are having a debate over it. If you go through the internet, you will find that debate is on. This does not mean that AI tool does not have its own benefit. It has a great deal of benefit. And therefore, suppose in the legal field, in a field of research, when documents need to be gone through, corrections need to be done, you can gather a whole lot of documents, say an arbitration clause. You can go through tons of documents, see how arbitration clauses were prepared, how the courts have interpreted, and a possible result could be given. But at the same time, we have had instances, both in India as well as in US, where the AI tool was used to do some research and it created a fake judgment altogether. The judgment which was non-existent was created by the AI tool, a fake citation was created, and the lawyer, trusting that AI tool, cited the judgment in court. In one of the US court, there is a judgment where the court held the lawyer responsible for not verifying whether the citation was genuine or not. Now these raise serious issues about governance of AI. Was the AI tool not obliged to tell right in the beginning a risk that this may happen? Should it not caution the user that please verify because there might occur such a mistake? And for that mistake which occurred and which the lawyer relied upon, who is responsible, who is answerable? Is it the lawyer responsible or is it the AI tool who should be answerable for that? These raise serious and very serious issues of governance and regulation, and therefore there is a growing call for regulating the use of AI, of having certain set principles of governance of AI, and considering the need for development of a framework of governance and also the need for a regulatory oversight, the Government of India framed a multi-state advisory group for development of an AI for India specific regulatory framework. A subcommittee was constituted to make recommendations for AI governance in India, and that governance principles included transparency, whereby an AI system should be accompanied by meaningful information on development, processes, limitations and capability. The AI tool should tell people that these are the possible errors which may occur. Please be cautious about this. Accountability, whereby the developers and deployers should take responsibility for the functioning and outcomes of AI system and for the respect of users' right and rule of law. So they should be answerable. And as I said, there are various concerns about an AI tool also having its own bias. One of the top companies in the world found that the AI tool which it was using for recruitment had a bias against women, because as the data fed in it was largely of last 10 years resume, which were largely by men, and therefore when it was suggesting candidates, it was a distinctly biased against women. It initially tried to tweak that and thereafter had to do away with that package altogether. So these are situations where accountability also needs to be cast on an AI tool. A compliance with various government requirements, which also should be there in the AI tool. Attempt or what are the safeguards provided to avoid discrimination, as I said, the instance which I gave you, that what are the steps in that AI tool to avoid discrimination, and there must also be mechanisms put into place for human oversight, judgment and intervention, especially in order to deal with complex ethical dilemmas and to reduce adverse outcomes on the society. So therefore, while an AI tool is an independent tool, the creator of it is a human being, and at times the inherent bias of the person feeding the data in it, the person creating it in it, creating that AI tool, become a part of the results which that AI tool gives. And there are inherent bias at times on the basis of caste, creed, religion, which could come out as a result of the AI tool. And there should be proper governance and human oversight to keep watching this and to avoid this. And therefore the subcommittee called for a proper regulatory framework also, because today the laws in India are spread over a wide spectrum of laws. There are not specific laws for AI. There are IT Act provisions which deal with certain aspects about cheating by personation or certain sharing of sexually explicit material, etc. Similarly, laws such as IPC also have certain offences about cheating by impersonation, about sharing and taking sexually explicit material, and POCSO has certain provisions, but there is not a single regulatory regime about artificial intelligence. Even the intermediary rules do not specifically deal with artificial intelligence and how they need to be regulated. And therefore, today there is an increased need for a regulatory spectrum which we should evolve about AI, and that will have to be developed and corrected at regular intervals, because it's a fast evolving technology. We cannot have a law which will remain static. I think whichever regulatory mechanism we formulate requires a look in every 2, 3, 6 months, because the world is moving so fast in this sphere that a static regulatory regime is surely not going to work. And therefore the subcommittee has also made various recommendations as to how there should be a technical secretariat by the ministry to serve as a technical advisory body and coordination point. It has made various recommendations which of course you all will deliberate upon in the day. I'm not going to read about all that right now. So sum and substance of it is that AI has become an integral part of our life today. We need to live with it. And it is of course making our life much easier, much smoother, and much more comfortable. But at the same time, left to operate just by itself, without any governance, without any regulation, without any human oversight, it may have very serious repercussions and very serious results. And therefore, today's seminar will serve a great purpose in discussing these aspects. And I'm sure you all will have a very healthy and fruitful discussion today. I would just like to conclude with a different note than the subject today. That in a world where we are so glued to a machine, where a good morning to you is also said by your AI tool, a good night is also said to you by an AI tool. Very often I find myself watching on my phone and laughing at a joke by myself. But can that AI tool be a friend, which each one of us has? It can help a doctor treat you when you are unwell, but will it be a soothing effect of a mother? It will not. So in this entire drive where we are using AI for just about everything, let us not forget the human side of us. Let us keep our human qualities intact, because I strongly and personally firmly believe that how much ever you train an AI tool, one thing it cannot have is conscience. And that is something which makes us human. And that feeling of empathy, that feeling of compassion, that feeling of fraternity, which our constitution requires each one of us to develop, that is something human, and that is something which can never be developed by an AI. And so therefore, in this whole drive of technology, let us not forget our human side, and let us also equally strive to keep that intact. Thank you very much.
Thank you so much, sir, for your insights on the benefits and challenges presented by the artificial intelligence. I am profoundly honored to introduce to you all Honorable Mr. Justice Ujjal Bhuyan, sir, Judge, Supreme Court of India. Honorable Justice Bhuyan, sir, was enrolled with the Bar Council of all northeastern states and practiced extensively before the principal seat and various benches of the Guwahati High Court, as well as before the Central Administrative Tribunal and other judicial forums. Over a distinguished legal career, he served as a standing counsel for the Income Tax Department for over 16 years, additional government advocate for Meghalaya, and special counsel for the Forest Department of Arunachal Pradesh, before being designated as a senior advocate and standing counsel for the Guwahati High Court. He was appointed as an additional judge of the Guwahati High Court in 2011 and later confirmed in 2013, and served as the executive chairman of the Mizoram State Legal Service Authority. His judicial journey took him to Bombay High Court in 2019 and then later to Telangana High Court in 2021, where he went on to serve as the Chief Justice. He also held positions of Executive Chairman of the Telangana State Legal Service Authority and Chancellor of Nalsar University of Law. On 14 July 2023, Justice Bhuyan was elevated to the Supreme Court of India following recommendation of the Collegium. He continues to contribute meaningfully to legal education as a member of General and Executive Council of NLS Bangalore and the General Council of MNLU Aurangabad. Justice Bhuyan, your rich judicial wisdom and commitment to legal reform offer invaluable insight, especially as we navigate the legal complexities of emerging technologies like artificial intelligence. We are deeply honored to have you with us and eagerly look forward to your address.
Dr. Dilip Ukey, the Vice Chancellor of MNLU Mumbai, Dr. Birendra Saraf, Senior Advocate and Advocate General of Maharashtra, Registrar Dr. Salukey, the faculty members who are present here, the resource persons who have assembled here, Advocate Akhilesh Dubey, whose book, there is an inaugural ceremony tomorrow with the second edition of the book. Mrs. Mia, who is present here. All the distinguished guests, my dear students, ladies and gentlemen. I think we are already running behind schedule. And my previous speakers have already covered, particularly the domain of IPR and AI, the interplay between the two. So I would not like to repeat what my previous speakers have said, but I would like to confine to the two subjects of privacy and security or data protection. But at the outset, I must thank the Vice Chancellor and the organizer of today's seminar for inviting me and my wife to be a part of this seminar. Last time we were here, it was in October 2023 on a seminar or symposium regarding space and aviation law. So from space and aviation law, now after 1.5 years, we are back to discussing privacy, data security, IPR and artificial intelligence. In fact, each of these subjects, according to me, are capable of stand-alone debate, discussion for the entire day, each subject. So what I propose to do is that I'll just refer to this in a capsule form and try to understand the interplay between these four subjects or the impact of these four subjects interplay on our lives, how it is impacting our lives. Let me first deal with privacy. Now, when we say privacy, we are not discussing privacy as a standalone concept. We are looking at privacy from the standpoint of rights-based jurisprudence. According to Black's Law Dictionary, a right to privacy means right to be left alone, the right to live without any unwarranted interference by the public in matters with which the public is not necessarily concerned. Right to privacy draws sustenance from an English common law maxim which says that every man's house is his castle. And in fact, this is very apt, even for the right to shelter. I spoke about 2 weeks back before the students of Bharati Vidyapith in Pune. Well, friends, the right to privacy has got two aspects. One, the general law of privacy, which is of course an action for tort, for damages. And the other one is the constitutional recognition against unlawful governmental intrusion or invasion. We are basically concerned with the latter. Let us examine how this right has evolved in India. It is not that this was not thought of earlier. In fact, in the 1800s, one Pardanashian woman, she filed a lawsuit actually. I think it was from Bombay here, the courts of that time, saying that I should be protected from the unwanted male gaze while I take the sun in my balcony. And she got an injunction. I don't know how that injunction could be effected or given effect to. You can always peek from behind your curtains. So I don't know how it would be like Section 9 of the Hindu Marriage Act. These injunctions can't be enforced. Anyway, so it is not of recent origin. But post-Constitution, adoption of the Constitution, the first case which comes to mind is the case of MP Sharma versus Satish Chandra. And it was a full bench, full court set. At that point of time, Supreme Court had 8 judges, and all the 8 judges sat in this court, in this case. And in this case, it was arising out of the search and seizure, power of search and seizure. A defense was put up as to that such search and seizure violated my right to privacy. The court declined to accept such a contention, saying that no such right exists under the Indian constitutional framework. Privacy is not a fundamental right. This is a case of 1954. Mind you, the law at that point of time, it was quite nascent. Article 21, it was still being looked at from a very conservative point of view. When we speak of Article 21, the first case which comes to mind is the case of A.K. Gopal. He was arrested, he was a communist leader, he was arrested under the preventive detention law. He challenged both the law as well as his preventive detention. Many grounds were taken. Two of the important grounds was that it violated 14, 19, 21. He also contended that though this preventive detention law is there, this is not a fair law. So due procedure clause, due process clause, as in the United States Constitution, should be read into our Constitution. Principles of natural justice should be read into the concept of life and personal liberty. The majority rejected this Constitution, saying that concept of natural justice is too nebulous, very, and we cannot read the Constitution in the context of such non-rigid or not such loose canons. So it was rejected. It was also rejected, saying that 14, 19, 21 are separate fundamentals. They can't be intertwined. But the minority opinion of Justice Fazal Ali, he differed. Primarily, he said that when we speak of Article 21, the law and procedure has to be just, fair, and reasonable. It is not enough to have a law. That law must conform to the principles of nature and justice. Maybe it was 1950, immediately after the Constitution was adopted, our nascent democracy was not yet ready to accept this viewpoint. So therefore, you find it even MP Sharma, this 1954. This is a conservative view taken. Similar view is taken 9 years later in Kharak Singh versus State of UP. There also, the Supreme Court rejected the contention that this right to privacy is inherent in Article 21. There is no constitutional guarantee of the right to privacy, the Supreme Court said. Now, in 1975, there was a case of Govind versus State of MP, Madhya Pradesh, where for the first time, Supreme Court accepted that there is a limited fundamental right of right to privacy as emanating from Article 21, also of 1918 and 19:1D. But the Supreme Court was cautious to say that such a right was not absolute and was subjected to reasonable restriction. This is 1935. In 1970, in the bank nationalization case, R.C. Cooper, those who are students of administrative law, constitutional law, will know that bank nationalization of 14 private banks was challenged. And it was interfered by the Supreme Court to a certain extent. The decision is per se not very relevant for our discussion today. What is relevant is that in that case, Supreme Court said that 14, 19 and 21 are not islands. They must be read as one composite whole. Violation of 14 may lead to violation of 19, violation of 19 may lead to violation of 20, or vice versa. So this is how the law is developed. Till in 1977, after the emergency was lifted, Maneka Gandhi wanted to travel abroad. The government of that day impounded her passport. So you can't go. She filed it, Article 32 petition, and contending that right to travel is a fundamental right traceable to Article 21. Right to travel includes right to travel abroad. The Constitution, I think it's a seven-judge bench. Constitution judge bench accepted her. There are other issues we did not go into, and said that it is not enough to have a law to deny the life and liberty of the person. The earlier view in A.K. Gopalan was that all that law required, Article 21 required, that there must be a statute which prescribes a procedure, and if the procedure is complied with, a person's life and liberty can be taken up. That was the earlier view. Maneka can be completely debunked. No, you can't do that. The law must not only be formal, it must be fair. That's the principle. Of course, there are other issues. So according to me, this 1977 judgment of Maneka Gandhi is a watershed in the Indian constitutional history. Post Maneka Gandhi, the Supreme Court virtually, took off a number of jurisdictions, PIL matters, environmental jurisdiction, jurisprudence, prisoners' rights, so on and so. Electoral reforms, so many. I'll come back to electoral reforms once again. So therefore, when you find that judgments thereafter, first 75 we saw, in that case, Govind. Thereafter, the judgments will show the evolution of the law related to privacy. In Madras Central Jail, there was one condemned convict, Otto Shankar. He is Shankar, but he was known as Otto Shankar. He was convicted for 6 murders and was sentenced to death. The reference was affirmed by the High Court. His appeal against the death sentence was rejected. Supreme Court had rejected his criminal appeal. At that particular point of time, his appeal or application for mercy was pending before the President of India. Now, the petitioners in this case, one was the editor and one was the publisher of a Tamil weekly called Nakiran, published from Chennai. And they said we will publish the autobiography of this Otto Shankar. He had written it, we will publish it. In fact, in their magazine, they had published 2 volumes, number 1, number 2. In that, Otto Shankar had named many IPS, IS and prison officers as being partners in crime. So naturally there was a fierce psychosis amongst these people. And they sought, an order was passed based on an alleged letter by Otto Shankar from jail. He said that I have not written any such autobiography. I have not authorized Nakiran to publish my autobiography. Therefore, it has nothing to do. Based on that, a letter was written by the Inspector General of Prisons to this Nakiran newspaper to stop publishing this autobiography. This case, it's called Raja Gopal versus State of Tamil Nadu, is very important for that, for 2-3 things. This Supreme Court said, first time, this is a case of 1995, the effect of Maneka Gandhi has started seeping into our constitutional jurisprudence. It says right to privacy is implicit. Of course, this is a 2-judge bench decision of Justice Jeevan Reddy and Suhas Sen. And that MP Sharma was by 8-judge bench. 2-judge bench said right to privacy is implicit in the right to life and liberty guaranteed to the citizens of this country by Article 21. It is a right to be let alone. A citizen has a right to safeguard the privacy of his own, his family, marriage, procreation, motherhood, childbearing, education, among other matters. None can publish anything concerning the above matters without his consent. This is the first thing the court held. Second thing, and this is very important in today's context also, in the case of public officials, it is obvious right to privacy, or for that matter, the remedy of action for damages is simply not available with respect to their acts and conduct relevant to the discharge of their official duties. This is so even where the publication is based upon facts and statements which are not true unless the official establishes that the publication was made with reckless disregard for truth. Now in this case, Supreme Court proceeded on the basis that, well, Otto Shankar did not give the permission to the newspaper, news magazine, to publish his autobiography. And thereafter, on these premises, they proceeded to lay down the law. Ultimately, the court held that the petitioners, meaning Nakiran, they have a right to publish what they allege to be the life story autobiography of Otto Shankar, insofar as it appears from the public records, even without his consent or authorization. But this must be based on the public record. If you go beyond that, then you will be infringing into his privacy, and you will be exposing yourself to action for damages, etc. The state or its officials cannot prevent or restrain the same publication. The remedy of the affected public officials, if any, is after publication. You can't prevent. There is no prior prevention of such articles. Now, thereafter, in 97, there was a case regarding phone tape. It's a People's Union for Civil Liberties versus Union of India, 1997. Allegations were of phone tapping by certain agencies. Supreme Court recognized that the right to have private telephonic conversations at home or at work without interference could be considered as a part of right to privacy. Court declared that phone tapping would infringe Article 21 unless it was permitted through a legally established procedure. telephonic conversations are an exercise of citizens' freedom of speech and expression under 19(1)(a). Intercepting telephonic conversations can be sustained only if it is justified on the ground of reasonable restrictions under Article 19(2) of the Constitution. 19(2), as we all know, is a reasonable restrictions for availing the freedom or limiting the freedoms under 19(1). In a very recent judgment, our bench, Justice Oak and myself, in the case of Imran Pratap versus State of Gujarat, we have said that it is an exception, and by its very nature, an exception cannot overshadow or eclipse the substantive rights guaranteed under 19(1). The reasonable restrictions must remain reasonable. It cannot be fanciful or oppressive. This is the view taken by the Supreme Court. 2009, we have established the Unique Identification Authority of India, providing for the Aadhaar card. This mandate of this authority was to give an identification number to a resident of India and to link it for the purpose of availing governmental schemes, etc. 2012, a retired judge, Justice Puttaswamy, challenged this project, saying that this violated a citizen's right to privacy and many more. A 9-judge bench of the Supreme Court in case Puttaswamy versus Union of India, this is 2017 judgment, delivered a unanimous verdict affirming that the Constitution of India guarantees to each individual the fundamental right to privacy. So this is a judgment by 9-judge bench categorically overruling MP Sharma and Kharagsi. The main opinion was authored by Justice Chandrachud, and of course there were many concurring opinions as well. The main opinion held that the right to privacy is an element of human dignity and is an inalienable natural right. It also focused on the informational aspect of privacy. Justice Rohinton Nariman, in his concurring opinion, he endorsed Gary Boswell's conceptual understanding of privacy as encompassing repose, sanctuary, and intimate decision. And he classified this right into 3 categories. Number 1, those which involve invasion of by the state into a person's physical body. Number 2, information privacy, which captures unauthorized use of personal information. And number 3, privacy of choice or individual autonomy over my fundamental personal choices, my lifestyle, my food habits, my sexual inclination. These are all within the domain of individual autonomy. There can't be any unwarranted intrusion into this. So according to him, restrictions on privacy will need to be tested based on the combination of rights. If it is a violation of 21 along with 14, then the test of arbitrariness and unreasonableness will come in. If it's a violation of 21 read with 19(1)(a), then the in-tune action, whether it is law or policy, will have to relate to the reasonable restrictions under 19(2). Justice Cole, in his concurring opinion, recognized such a right against both state and non-state actors. Please read. These opinions are very important actually. Insofar the state is concerned, he identified surveillance, much has been said about surveillance by my previous speakers, and profiling as major areas of concern, whereas in respect of non-state actors, he emphasized on the impact of technology in the form of pervasive data generation, collection and use in a digital economy. He highlighted the influence of big data and the resultant chilling effect it may have on free speech. Now, this brings us to the next limb or the next subject, which is security, the concept of security. Now, when we speak about security, it has to be understood in the context of data protection. Now, we have that Information and Technology Act 2000, object of which was to facilitate e-commerce, because we were transitioning from the traditional system of commerce into e-commerce. To facilitate that, the Information Technology Act was enacted, and also to provide for a regime of electronic evidence, 65E and all those. Now, after the challenge to the Aadhaar project, the government thought that the Aadhaar project must have a statutory backing. Till that point of time, we did not have a statutory backing. So the Aadhaar targeted delivery of financial and other subsidies, Benefits and Services Act 2016 was enacted by the Parliament. This was again challenged by Puttaswamy. This time, the majority, led by Justice Sikri, they upheld the constitutional validity of this act, the Aadhaar Act, though certain provisions were struck down as unconstitutional. They supported that the view that this the Aadhaar Act, objective of the Aadhaar Act was to provide or to link people with government beneficial schemes, and therefore it could have been passed as a money bill. That was a challenge, that Aadhaar bill could not have been passed as a money bill. In fact, the amendment to the PMLA, Prevention of Money Laundering Act, was also passed as a money bill. That is again under challenge. I will not comment on that because that's a live issue. The matter is still alive. The challenge is still pending. But the court struck down linking of Aadhaar with bank accounts. They said this will infringe or intrude into your private domain. Now, the minority opinion of Justice Chandrachud is very important. Chandrachud completely disagreed with the majority. And he stressed upon the incoherence between the biometric model deployed by Aadhaar on the one hand and the right to remain anonymous of a citizen. According to him, anonymity is central to a person's sense of freedom and autonomy. Widespread use of biometrics undermine the right to remain anonymous. He also found fault with the Aadhaar Act on a number of other grounds, including the absence of an independent monitoring authority. He was of the view that there is no conflict between the right to privacy and the legitimate goals of the state. An invasion of privacy has to be proportional and carefully tailored for achieving a legitimate aim. According to him, the Aadhaar scheme is capable of destroying different constitutional identities and is inadequate to protect the integrity of personal data, the right to informational self-determination, and the rights attributable to the privacy, dignity, autonomy trilogy. And he had cautioned that the Aadhaar scheme may lead to a surveillance regime impacting fundamental freedoms and rights. Now, post Puttaswamy 1, which held that right to privacy is a fundamental right, traceable to 21, the government felt the need to bring in a legislation to protect personal data. And therefore, a committee was constituted, headed by Justice Sri Krishna, former judge of the Supreme Court, in 2007. This committee submitted a report, and this report formed the basis of the Personal Data Protection Act 2023. Now, this has come into force. Now, this act recognizes that rights of individuals to protect their personal data on the one hand, and the need to process such personal data for lawful purposes. Of course, various stakeholders have raised serious concerns about certain provisions of this Act, saying that these provisions are too broad and sweeping and therefore susceptible to misuse. For example, Section 17(2)(a) of this Data Protection Act says that provisions of this Act would not apply in respect of processing of personal data by such instrumentality of the state as may be notified by the central government in the interest of sovereignty and integrity of India, security of the state, friendly relations with foreign states, maintenance of public order, or preventing incitement to any cognizable offence relatable to these. Similarly, Section 36 empowers the Data Protection Board of India to furnish such information if called for. Now, Section 43, subsection 3 has amended Section 8 of the Right to Information Act 2005. Earlier, Clause J of Section 8 of the Right to Information Act prevented personal information from being disclosed only if such personal information was relatable to your public duty, discharge of public duty, your public interest. Now, as per this amendment, there is a wholesome exemption. Now, this information, which is simply personal, is exempted from disclosure. So, therefore, a public official can refuse to divulge information citing Clause J of Section 8 of the amended Right to Information Act. Right to information, as the law has evolved in this country, is again a fundamental right. Right to know of a citizen, traceable to Article 19(1)(a) of the Constitution. We cannot have a situation where data protection, which is based on the right to privacy, is pitted against the right to information. They are not mutually exclusive. Then, of course, the third subject is IPR. It has already been discussed. I will not go into that, except that I am reminded of much water has flown since then. It is in 1997 that the former Chief Justice of India, Dr. Justice Anand, had beautifully summed up what is IPR. It's published in the Supreme Court Law Journal. And he said that intellectual property as a class presents different issues and situations than other property, and because of its strategic exploitation, it poses different questions. Intellectual property differs from other forms of property because of uncertainties regarding its value and how it can be used. Intellectual property cannot be kept in a safe deposit vault, cannot be deposited in a bank, cannot be locked in a house. It is there in the public domain in the form of copyright, trademark or trade name. And it is easily available to the general public and therefore can be easily stolen. So therefore we have an entire regime of acts to prevent or to protect IPR. So what is IPR? Intellectual property rights. Rights which accrue, rights relating to property which accrue out of our intellect. Therefore, Justice Sikri says that it is essential to protect IPR. To take away IPR would be to deny the creators the right to profit from their labor. Artificial intelligence, we all know, much has been said, and it has the positives and the negatives. It has led to racial profiling, automate decision-making, policing in the United States, and which has led to racial profiling. We can't rule out that in India also, where we already have so much of bias in the system. Ours was we practiced, till the Constitution was adopted, we practiced graded inequality. The Constitution is a transformational document. Constitution has taken us out from that graded inequality to a regime of equality. Article 14. It's so simple to read now that all men are equal, men and women are equal. It was not so in the distant past. Even now, there are many who have this mindset that men are not born equal. So, dear friends, you are in a law university. When we have the Constitution, our allegiance is to the Constitution. Our first and foremost allegiance is to the Constitution and the preamble and the principles espoused by the Constitution. The principles of equality, the principles of fraternity, the principles of brotherhood, that we are all equal and that we are all governed by a rule of law. Friends, at the end of the day, I am not going to how this AI is there to say, but AI has also the negative impact on us, including on IPR. In some jurisdictions, it has been clearly held that AI created innovations, there can be no patent. But in South Africa, they have held it to be so. So, a company or a corporation having business activities across jurisdictions may find that their AI innovations, creations are acknowledged in one jurisdiction, but not so in other jurisdictions. So it may lead to a lot of complications. But as pointed out by Dr. Saraf, at the end of the day, we are dealing with human beings. We don't want an AI judge who decides cases allowed dismiss, allowed dismiss. We don't want that. We want a judge who gives reason. The lawyer in front of the judge is not driven by artificial intelligence. He is a human lawyer. And in most cases, 95% of cases, we are dealing with natural human, not artificial persons like corporations. 95% of the cases. Dignity of human being is paramount, and this is what right to privacy says, and must be respected. Individuality of a human being, his individual autonomy and creativity must be protected. At the same time, we must also remember that ours is a liberal democracy governed by the rule of law. While on the one hand, right to privacy of an individual, which is a fundamental right under Article 21, must be protected. But at the same time, a citizen's right to know or the right to information, which flows from Article 19(1)(a), cannot also be disregarded. The right to know is a potent weapon in the hands of the citizenry to seek accountability within the framework of democracy. Let me go back to the electoral reforms. Supreme Court had employed the right to information, the right to know concept, and directed the Election Commission to mandatorily require contesting candidates to file affidavits disclosing his wealth, criminal antecedents, so on and so forth. It has led to amendment of the Representation of the People Act. Now, can these people say that by disclosing all this, my right to privacy is violated? Just as right to privacy of an individual is important, the right to know, or the right to information of the collective citizen is equally important. It is not that right to privacy and right to information or right to know cannot coexist or are mutually exclusive. There is no antinomy between the two. A healthy and a vibrant democracy needs both. Friends, this is indeed a topic of serious discussion. I must congratulate the organizers for choosing this topic for today's symposium. And I am sure today's deliberations will go a long way in helping us understand the subtlety of the interplay between these two fundamental rights, right to information on the one hand and the right to privacy on the other hand, and how we need to protect both. Thank you very much, and God bless.
Thank you so much, sir, for your insights. We are truly honored to welcome Ms. Pooja Kapadia ma'am, one of our esteemed expert speakers who has just joined us. May I now request Honorable Registrar Sir to kindly felicitate Ms. Pooja Kapadia ma'am. We are delighted to announce the exchange of a Memorandum of Understanding between the Maharashtra National Law University Mumbai and Sihagarh Institute of Technology Pune and Medico Legal Society of India Pune. May I now invite Honorable Vice Chancellor Professor Dr. Dilip Ukey sir and Professor Dr. Rajiv Joshi sir to kindly come forward for the formal MOU exchange ceremony.
Now I would like to invite Assistant Professor Ms. Asa Tiwari ma'am to deliver the vote of thanks.
Good morning everyone present here. It's indeed my pleasure to deliver a vote of thanks today. On behalf of Maharashtra National Law University and the entire organizing committee, I extend my heartfelt gratitude to everyone present here. We are deeply honored to have you, sir, with us. Chief guest, Honorable Mr. Justice Ujjal Bhuyan, sir. Your insightful words have set the tone for the discussion, and it reminded us the immense responsibility that we have today towards the use of artificial intelligence in the legal field. I would also like to thank Mrs. Bhuyan ma'am for gracing the occasion. We are so glad you are here. Our sincere thanks to Dr. Birendra Saraf sir for his thought-provoking address. My heartfelt gratitude to all the guests present here, Sachin Daga sir, our partner, associate partner for the event, Dr. Udit, Hall ma'am, Ankita ma'am, Gauri ma'am, everybody who is here. Our partners, LiveLaw, Manupatra, AIR. A special thanks to our Vice Chancellor, sir, Professor Dr. Dilip Ukey, for his leadership and unwavering support, without which nothing would have been possible. Our faculty members, our teaching, non-teaching staff, especially our assistant registrars, Shyam sir, Amit sir, who have been a constant source of support, and our team, the two pillars behind this organizing event, Shweta and Ankita. without whom it would have not been possible. Our entire organizing team, thank you so much. As we move into the technical session and paper presentation, we look forward to the thought-provoking discussion and meaningful collaborations. Thank you so much once again for gracing the occasion. Thank you so much.
I request the dignitary to wait for 2 minutes for a photograph and further request all the participants to. I request everyone to kindly rise for national anthem.
First we'll be having the group photograph, then we'll stand up for the national anthem. And I request participants to be seated till then.